Hello guys and welcome to the Legis Law channel. In this particular session, I'm going to be taking you through how to prepare adequately towards the Ghana School of Law entrance exam. Now, the Ghana School of Law entrance exam is conducted once a year, and the format for this particular year, 2024, is a 3-hour period, 6 questions. The students must tackle 4 questions, and the questions cover the courses Constitutional Law, Contract Law, Ghana Legal System, Criminal Law, the Law of Torts, and Immovable Property Law. Now, this particular session is going to take students through what is known as the SRAGIE method. Right, so we have the SRAGIE method, that is SRAGIE. Now, the S stands for the study guides, the R stands for the revision techniques, the A stands for the accountability, the G stands for group studies, the I stands for the IRAC method of answering questions, and the E stands for the essay method of answering questions. Now, these particular strategies are very important in preparing students adequately towards successfully passing the Ghana School of Law entrance exams. So, what is the study guide method? Now, obviously, the name speaks for itself. The study guide method is supposed to lead or direct students in preparing adequately towards a particular course. Now, for a study guide, it is a short comprehensive outline or a short comprehensive note, or it can be in the form of a soft copy or a hard copy. Now, this particular outline is divided into 2. It has the principle of law within that particular course, and it also has what is known as the authority. So usually, the best way to prepare a study guide is to have the principle of law on the left-hand side, right, the principle here, and then the authority is on the right-hand side. This is because in answering any law question in this particular exam, you are going to be tackling either an essay question or a problem question. For every legal statement that you make, you most of the time would require an authority, that is a legal backing. So the authority can come in the form of a constitutional provision or a statute or a case or even a textbook. It can even be in the form of international law or customary law, as well as a principle of equity. So these are constitutional law provisions, statutory provisions, case law, textbook, international law, and also the customary and equity principles. Now, in that sense, when you state a principle of law, then you back that particular principle with an authority. So, for example, under criminal law, we have the principle of legality. The authority is under Article 19, Clause 11 of the 1992 Constitution of Ghana, which states that no one should be punished for a crime unless the offense is written with the punishment prescribed. So another example is for constitutional law. So for constitutional law, we have a principle known as the supremacy of the Constitution. So for the supremacy of the Constitution, the authority is Article 1, Clause 2 of the 1992 Constitution of Ghana, which provides that the Constitution is supreme and any law that is inconsistent with the Constitution will be declared null and void to the extent of the inconsistency. So you realize then that for every principle of law, like constitutional supremacy, separation of powers, coup d'etat, enforcement of the Constitution, etc., there will probably be a provision in there. Now, the provision can also be in a statute, like the Contracts Act, the Sale of Goods Act, the Lands Act of Ghana. So the Lands Act 1036 has a lot of statutory provisions regulating the land law in Ghana. So in that sense, when you have your short outline of the principles and the authority, you can now move on to what is known as the revision techniques. So the R in there stands for revision. So you take a lot of time preparing your study guide. You pick up your notebooks, your textbooks, your lecture notes, you consult seniors and even practicing lawyers, and get principles under contract law, constitutional law, criminal law, etc., and then get the corresponding authority. Now, when you've completed your compilation, you are supposed to revise that particular compilation. So the mistake that most students do is to create their compilation of principles and authority at the later end of the period when they are very close to writing the exams. That is very wrong. You are supposed to even have the compilation prepared about a month or two towards the exams. Then you spend that particular month or two, instead of reading new sources like reading the constitution for the first time or reading a textbook for the first time, you are rather revising. So the revision here can also stand for repetition. Now, it is essential to spend more time revising and repeating what you studied than trying to accumulate new information, because the brain is also an organ or a muscle, and this particular brain, is more concerned with what is being revised over and over again. It makes it easier to remember. So the R in there stands for the revision techniques, and the only strategy or advice I can give you for revision is to basically make sure that you are repeating the principles and the authorities, the case law, over and over and over again every single day. So every day I'm reading my constitutional law study guide. Under the supremacy of the Constitution, I know Article 1 Clause 2, and I know the case of to foreign Attorney General. So supremacy, I know Article 1 Clause 2, I know the case of to four and Attorney General. So we also have enforcement of the Constitution. I know the particular provisions are Articles 2 Clause 1 and Article 130 of the 1992 Constitution. I know cases such as NPP and Attorney General, even the same to four and Attorney General, Mensima and Attorney General, and many other cases. The point I'm trying to say is that I'm able to remember my case law and my principles easily because of the revision. And the revision here is based on repetition. So every single day, you can apportion 30 minutes or 1 hour for revising your whole constitutional law study guide. Once you have all the principles, once you have all the cases, you spend enough time rereading it and trying to repeat it to yourself or practice with others. So this takes us to the next stage, that is the stage of accountability. Accountability is very important for a law student because as a student, you might find yourself deviating in terms of picking what to study or even preparing adequately towards the paper. Now, in reference to accountability, I'm speaking more or less of a particular senior. So I'm talking about any senior in the legal practice. It can be your lecturer who is your senior. It can be a legal practitioner or a lawyer who is also your senior. Someone that you know who has substantive or practical knowledge in the course. Now you are making yourself accountable to this particular person, that is the senior. You are reporting to the senior. You are asking the senior questions. And you are also asking the senior for feedback on some of the practicals that you've done. Now, most of the time, the senior can also be a law mentor. So, for example, what I'm doing right now is law mentorship. I'm trying to, advise or take students through certain tactics or techniques towards writing the paper. So, your senior can be someone who might not know you personally or has never met you before, but you can interact with him or communicate with him, asking him law questions and techniques. In that sense, it makes you accountable because you have someone that you report to, or you have someone that you ask for feedback. You are able to get certain directives and instructions which can propel you. Now, the next stage is the gene. So the gene is referring to the group studies. Of course, now that you have your study guide and now that you've revised the particular topic, how do you know that you are good at this topic? You can practice with the senior, of course, but it's also important to interact with your colleagues. Your colleagues are people who are also preparing towards that particular course. I assure you that when you are in a group of similar like-minded students who are preparing for the same exam and they are studying the same things and you're asking yourself questions and having group studies to discuss the law, you end up revising. You end up being accountable. And you end up also receiving feedback from your colleagues. So yes, there is the senior, but then the senior might not even have enough time to interact with you. But for a group that is a law group of students, you are basically focusing on studying together, training together, learning together, and practicing together. So with the study group, I entreat you all to find a group of 6, 7, 3, 4. It doesn't matter the number, as long as you are all focused and diligent and you know what you are about. You could get a number of law questions and you could practice. You could also contact the senior. So the group can contact the senior. So for example, in my master class, I'm a senior of about 400 law students, right? I have the 400 law students in the group. So every morning at 5 a.m. to 7 a.m., I'm taking them through past questions. And also in the evenings at 9 p.m. to 11 p.m., I'm taking them through past questions. So within a month, they spend 4 hours daily solving past questions. And so for the 30 days in the month, that is 120 hours solving past questions. Now, there are other students who are not in any group. There are other students who are not having interactions with seniors. Now, the 120 hours of preparations and practice with your senior will substantively make you better prepared than someone who is trying to learn independently. It doesn't mean that the person will not pass. It simply means that you are increasing your chances of passing. Remember, it is also a competition. So anything that you can do to increase your chances of passing by preparing study guides, by revising, by making yourself accountable to a senior, and by joining a law group is essential. Now, the last two are actually doing the particular exam. It is referring to the IRAC method and also the essay format. So I'm going to take you through how to answer IRAC questions. There was a prior video that I did that was specifically on how to tackle IRAC questions. Now, the IRAC questions are dealing with problem questions. So there are two types of questions that will be asked in the Ghana School of Law entrance exams. Either a problem question or an essay question. Now, sometimes there are hybrid questions. So a hybrid question can be a combination of problem and essay questions, just in the format. So for a problem question, they give you a set of facts. You are supposed to raise the issues from the facts, right? The issues from the facts. You are supposed to also identify the relevant rules that are the authorities or the law. Then you are also supposed to analyze or apply the facts. So that is the analysis or application. So you are applying the facts or you are applying the rules to the facts. So you are applying the rules to the facts. So when you've identified the relevant facts, you then apply the rules to the facts. So this is the application or the analysis. And then you reach a conclusion and you advise the parties. So that is the IRAC method. Now for the essay method, right, it's usually a direction to give your particular legal opinion on a matter or to discuss a matter of law. So it is generally speaking an essay. And you know with an essay, there are three main parts. We have the introduction, we have the main body, and we also have the conclusion. So with the introduction, you are supposed to identify the topic sentence. What is the specific matter you are writing on, right? So with the intro, we are looking at the topic sentence. Once you've correctly identified your topic sentence, you're also going to do an address of the topic sentence. So this is the main body, right? An address of the topic sentence. This is the main body. And then you also have your conclusion, right? Which is a summary of the address. So the main body can be divided into numerous paragraphs. Any central point you are making or any forwarding point you are making, you are addressing it in each paragraph. So each paragraph is expressing a central theme or a central idea. It makes your work very organized. Now, you realize that I'm not going into detail with the essay and with the IRAC because there are different sessions or tutorials that I'll go into this particular IRAC and essay format. But the essential thing to know is to practice questions over and over again to identify and understand how to apply these formats. That is the AC format and the IRAC format. For the hybrid, as I was saying, they might instruct you with a set of facts. So they might give you a problem question and you not address it using IRAC alone. You can write it in a memo. So they can inform you to write a memo or even a memorial or even a legal address to maybe a particular group. So a legal address to a group, or even you can be told to write a judgment. So of course, as I said, the IRAC is the issues, the rules, the application, and the conclusion. But then with the memo, there's a different strategy. With the memorial, there's a different strategy. They just simply have a different format. So although they contain the IRAC, some of them will have maybe a statement of the title, a statement of the person who is making the address and who they are addressing it to. So usually with the memo, you are addressing a superior in your field. Maybe the instruction has been given to you to write a memo to your superior. So it is coming from you, the student, or whatever particular office you are in within the problem question, and then you are writing the memo to your superior. So with the memorial, it's also similar, but usually in debating or mooting, you can be instructed to write a memorial. So usually with the memorial, there is also a statement of facts, very detailed, a statement of relevant facts. Then you can have a statement of the rules and authorities. So it's basically similar to the IRAC method. Then a legal address must have a title, and you must state the particular topic you are addressing on, and then the particular group that you are addressing it to. And then for a judgment, it's similar to any Supreme Court judgment. So with the Supreme Court judgment, they will have what is known as the name of the court, right? So for the Supreme Court judgment, we have the court. So that is in the Superior Court of Judicature in the Supreme Court of Ghana. So after stating the court, you state the quorum, maybe the judge. So maybe you are the judge in this particular matter, right? But even between the court and the judge, what is the matter before the court? So that can be the title. So just in case you've been given a title to address, maybe the Republic versus Kofi Mensah, or the state against Kojo Menu, or Jojo and Attorney General, you can have that as the title. So this is the case before the court, and then this is the judge. That is particularly you are writing your judgment. So your judgment, you usually write the facts, right? You also have the memorandum of issues, and then you also have what is known as maybe a statement of jurisdiction. Usually the jurisdiction is settled first, right? A statement of jurisdiction. So the Supreme Court will establish that it has jurisdiction in the particular matter before they address the matter. If they don't have jurisdiction, do not address it. Now with a judgment, the court will consider the argument of both sides. So they will consider the plaintiff argument and the defendant's argument, or the appellant and the respondent. So we can also have the appellant's argument, and we also have the respondent's argument. Right. So in this particular case, the judge will address the argument on both sides, and then will give a legal analysis, okay, or the analysis of the court. So the court will give its legal analysis. That is the legal opinion of the court. So in the legal opinion, the judge will raise the authorities and then apply the authorities. So with respect to the legal opinion, we have the authorities, and we also have an application of the authorities, right? The authorities and the application of the authorities. So that is within the legal analysis. And then finally, the judge will give a conclusion, right? That is a final statement or a declarative statement on the position of the parties in that instance suit. So remember, the strategy, right, is to use the SRAGIE method. That's what I'm proposing for most of my students. So first of all, you need to prepare study guides, then you revise the study guides and repeat them consistently every single day. Then you are also making yourself accountable to a senior, right? And then also you have a group, that is colleagues that you are studying with or practicing with. Then usually you are answering questions and submitting those particular answers to the senior to mark or give you feedback. And then we also have understanding or tackling how to answer questions using the IRAC. So these are restricted to problem questions. And then you also know how to answer essay questions using the IRAC. And then you need to also appreciate the different forms that these particular questions can come under. You can be instructed to give a legal advice or a legal address, or write a memo, a memorial, or even a judgment. So they can instruct you to write a judgment as a particular judge in this matter. So these are the key means of preparing adequately towards the Ghana School of Law entrance exams. So with respect to time, there will be release of more and more videos to go into the specifics on how to prepare study guides, how to revise adequately, how to make yourself properly accountable to a senior, how to have an effective group, and then also how to tackle IRAC and essay questions. Thank you very much. Now, if you found this particular video very useful, I would like you to share and subscribe and also like this particular video in order to promote it more to other students who might be preparing towards the Ghana School of Law entrance exams. Till next time, tada!